Hi, I'm Anna Denton-Jones of Refreshing Law Limited, and as you can see, I'm in the process of decorating the office at the moment, so you'll have to forgive the bare walls. Purpose of today's video is to talk about a collective redundancy related case that's come out of the European Court of Justice. Now, I'm recording this on January the 19th of 2021, so if you're watching this, you may be thinking, hang on a minute, what about Brexit, and does EU case law such as the one you're talking about today have any bearing on us anymore? And the answer to that is yes. All of the retained, it's called, EU law that was in force when we left is still relevant, and our judges can still take into account developments in the European Court of Justice when interpreting that retained case law. So it is still important that we understand what is going on in Europe and what that might teach us about our law here in the UK. So as I said, the case that I'm thinking of is a collective redundancy case. So as you know, Section 188 of the Trade Union Labour Relations Consolidation Act tells us that we have to collectively consult if we are proposing to dismiss as redundant 20 or more people in one establishment within a 90-day period or less. And the length of that consultation period depends on the numbers of potentially affected staff. So where we're talking between 20 and 99, then it's a 30-day consultation period, and where we're talking over 100 people, then it's a 45-day consultation period. Under the European law, they still do a 90-day consultation, whereas we have a shorter period here. Now, what happened in the particular case, it's called UQ, as in the letters U and Q, and Marclean Technologies. So it's a Spanish case, and what happened in that case was a number of people stopped working for the employer within a particular period between the 31st of May and the 14th of August. 7 people left for a variety of different reasons. And then on the 15th of August, 29 people resigned and went to work for another organisation. And as a result of this mass departure of staff, the organisation actually ceased trading. Now, one of the individuals who lost her job in the nuclear fallout from all of that tried to argue that there was a hidden dismissal, collective dismissal in amongst that because of the numbers affected. And as part of looking at it, the Spanish courts referred the case to the European Court of Justice to ask about the particular time frame as to when you're assessing that 90-day period. Is it 90 days looking forward? Is it 90 days looking back? Is it a mixture of those things? What should they be doing? And essentially, the courts have said that they wouldn't want to constrain, if you like, the protective effect of the legislation on individual workers, so that it is a mixture of looking back and forward. How does that fit in with our UK legislation? Well, it's interesting that our Trade Union Labour Relations Consolidation Act specifically says that Section 188 small bracket 3 that when determining how many employees an employer is proposing to dismiss as redundant, no account will be taken of employees in respect of whom consultation has already begun. Now, this decision suggests that if you had a circumstance where maybe an employer was making redundancies in batches, let's say, for example's sake, 10 employees were affected initially, at that point in time, the employer would be quite happy that they fell outside of the collective consultation obligations. But what happens if shortly, within a couple of months down the line, we want to make a second batch of redundancies? Now, often we've already dealt with those 10 and they've actually left by that point. But let's say they've got long notice periods and they're still there. Do we then, if we're going to add 10 in a second batch, now say, well, we've still got 10 people who are there, 10 plus 10 takes us over the line into 20. Actually, we should be consulting all of those people. And effectively, that's what this European case is saying, that yes, we should. That's also going to have a knock-on effect with things like filling in the HR1 form for the Secretary of State about numbers of dismissals as well. So it's worth understanding that that change has happened and getting some further advice if you are likely to be making redundancies in batches. And certainly with COVID, there may be employers for whom that is likely, if you've made redundancies, hoping to curb numbers and keep them low, and then perhaps unfortunately have to make a second batch later on. This could all become relevant. So please do take advice on that issue if you are making redundancies in waves. If you've got any questions, please do ask. It's adenton@refreshinglawltd, the shortened form of limited.co.uk. Thank you very much.